The network made an unparalleled contribution to equality, diversity, and inclusion by hosting guest talks with judges from the Supreme Court of Ukraine during the Russia-Ukraine war, as well as the Supreme Constitutional Court of Palestine and Supreme Court of Israel during the peak of the Middle East crisis. 70% of participants during Global South Network activities since its launch in March 2023 were women. We demonstrate the Global South is not a passive recipient of ideas but an active contributor shaping global norms. Today we are privileged to host Honourable Justice Michail Pikramenos, President of the Hellenic Council of State, Supreme Administrative Court of Greece.
I don't like the long presentations and the long speeches. Dialogue is better than monologue. The case law of the Court of Justice of the European Union and the Strasbourg Court has been instrumental in modernizing national approach to important issues in the field of rights. There is a violation of the European law. The Special Supreme Court, our court, was wrong, in very simple words. Public trust in the European judiciary varies significantly from country to country. However, the level of trust cannot be viewed as distinct from the general differences between high trust societies, mainly in the northwest of Europe, and low trust societies, mainly in the south and east. Historical, social, and economic reasons account for these differences. Trust is the bedrock of any successful operation, whether it be private or state. Judiciary is not in competition with other branches of power, but it is fundamental that trust established and there is a recognition of its independence in the way of its function.
Deseo expresar mi sincero agradecimiento al Dr. Naumen Riaet, la conferencia dada por el magistrado Michail Pikramenos, presidente del Consejo de Estado Helénico de Grecia.
Dr. Naumen Riaet, the founder and convener of the Global South Network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riaet's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism. In these days of backsliding of the rule of law, rising authoritarianism and polarization, it is of utmost importance to strengthen mutual understanding and trust.
Despite the fact that Russian armed forces have been near Kyiv, the Cassation Court did not stop its operation concerning judicial proceedings and continued its work. Despite the Russian invasion and air alarms, other horrible things of war in all our Ukrainian regions. To express my appreciation for your assistance, for your help in our fight against unjustified war.
Supreme Courts are sovereign. We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations. Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Riyad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
I would like to invite Honourable Justice Kari Kuusiniemi'S, President of the Supreme Administrative Court of Finland, to share their comments. Over to you, Honourable Justice Kari.
Thank you so much, Chair. It's a great pleasure and honor to take the floor in today's important event. Allow me to begin by paying tribute to Dr. Nauman Riyad, who is the founder of the Global South Network. And I can only echo what the preceding speaker, President Molemela, was saying. But I would like to point out that Dr. Riyad's initiatives have not only enriched comparative judicial dialogue, but have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism. In these days of backsliding of the rule of law, rising authoritarianism and polarization, it is of utmost importance to strengthen mutual understanding and trust. But obviously, I also wish to extend my deep appreciation to my distinguished colleague and dear friend, Honourable President of the Hellenic Council of State, Michail Pikramenos, for his insightful and thought-provoking lecture. But first things first, Michail, my friend, I want to congratulate you on behalf of the bronze medal in the basketball European Championships, where Greece crushed the Finnish team called Wolfpack. I'm trying to recover about that. And the reflections of Michail on the interaction between national administrative law and jurisprudence of the European courts illuminate how administrative courts in Europe must navigate an increasingly complex legal environment while upholding both national traditions and supranational obligations. From the perspective of the Supreme Administrative Court of Finland, there are many parallels in our judicial responsibilities, no wonder. Like the Greek Supreme Administrative Court, we operate as the final authority in administrative law disputes, ensuring legality in governance, protecting fundamental rights, and guiding legal development through precedent. The challenges we face, from environmental protection and climate policy to immigration, taxation, and social welfare, often require balancing national decision-making with compliance under European Union law and international human rights obligations. Despite these similarities, important differences exist in the scope and nature of their powers. The Council of State of Greece primarily hears petitions for judicial review, annulment of administrative acts for excess of power, deciding in first and last instance. Some categories of such cases, due to their nature or importance, fall under the jurisdiction of administrative courts. Ordinary administrative courts also exercise full jurisdiction in the first instance, while the Council of State reviews their final judgments. But on the other side, the Supreme Administrative Court of Finland, which was established 170 years ago in 1918, is the highest court for administrative cases in Finland, while the Supreme Court handles civil and criminal matters. So we have two parallel court lines, just like in Greece, but unlike in South Africa, for instance. The court's mission is to provide judicial protection and guide the application of law through precedent. It serves exclusively as the judicial body, with its primary mission being a provision of judicial protection and interpretation of administrative law. But even if it's not a Council of State after the model of, for instance, France, which we'll certainly hear more closely in a moment, my court also delivers opinions concerning draft legislation and may also, under the Constitution, submit initiatives to government to amend legislation, obviously in practice with regard to enhancing legal protection, safeguarding of the rule of law, and developing administrative procedure. In the court, cases require almost exclusively leave to appeal, and they are handled in writing. But the court may also hold oral hearings and on-site inspections, for instance, in environmental cases. The court receives and decides about 4,000 cases annually, mainly concerning immigration, taxation, social welfare, environment and land use, as well as regional and municipal administration. Its decisions are final. The court is composed of the president, 22 justices, and supported by some 90 staff members, including referendaries, who are presenting the cases and writing their judicial assessment in their very profound memos. The system of leave to appeal reflects Finland's emphasis on judicial efficiency and accessibility. Linking to President Pikramenos' emphasis on EU and international human rights law, it's important to mention a couple of examples of rulings of the Supreme Administrative Court of Finland. I will mention two recent climate cases. By the way, these cases or other judgments can be found on our web pages in English translations. So the first one, which was decided in 2023, the appellants, two nationwide NGOs, challenged the Finnish government's annual climate report, arguing that it failed to include the required assessment of additional measures needed to achieve climate targets, despite evidence of collapsing carbon sinks. They claimed that the omission violated the National Climate Act and demanded that the government's decision be repealed and returned for further preparation. However, the court dismissed the appeal, ruling that submitting the annual climate report to Parliament was not an administrative decision subject to appeal. The court noted it could only intervene if the government's inaction or refusal to take necessary measures clearly violated the Climate Act or demonstrated disregard of its international obligations, that is the Paris Agreement for first and foremost. In this case, however, the court found no evidence of such neglect and held the government's action was not an appealable administrative decision. But in 2025, in the second climate litigation, the assessment of admissibility changed, mostly because of the effect of the European Court of Human Rights Grand Chamber judgment in the notorious case Klimaseniorineen. Even if Finnish government's annual climate report to Parliament under the Climate Act was not appealable, as only decisions amending climate policy plans could be challenged, the Supreme Administrative Court interpreted the appealability extensively, referring to the case Klimaseniorineen, and decided to examine the appeals. However, the court emphasized that the government holds primary responsibility for climate policy in line with national and international obligations, while the court's role is to ensure decisions comply with the law and protect fundamental rights. Although climate change poses serious human rights risks, the court held that finding the government in violation for inaction requires a high threshold given the constitutional separation of powers and the complexity of climate policy decisions. It goes without saying that we have tens or hundreds of cases where EU law and human rights law is tackled, but to save time, I will not go into those decisions or judgments in more detail. But as a kind of a summary, I would say that the Supreme Administrative Court not only ensures judicial protection domestically, but also actively contributes to the international exchange of judicial practices. The court engages in both regional and global cooperation with supreme administrative jurisdictions. I might mention the acronym ACA Europe, which was already at the outset mentioned by President Pikramenos. That's the Association of Councils of State and Supreme Administrative Jurisdictions in the European Union. That's a very, very important platform, and I'm happy to tell you that President Pikramenos has taken over the presidency from me to the next 2 years, and I wish him and the court the best of success. To conclude, it is in this shared space facilitated by the Global South Network that international cooperation among Supreme Administrative Courts becomes indispensable. Exchanges such as today's dialogue allow us to learn from each other's experiences in adjudication complex issues of public administration, human rights, and regulatory governance. The network plays a particularly important role by connecting European and non-European jurisdictions, which today's event is a paramount example. In this sense, the network under active leadership of Dr. Riyad is not only fostering dialogue, but also building bridges between courts, traditions, and continents. It is my sincere hope that these bridges will continue to strengthen, enabling us to work together in advancing the rule of law, judicial independence, and good governance worldwide. Thank you so much for your attention.
Thank you, Honourable Justice Kari Kuusiniemi, President of the Supreme Administrative Court of Finland, for your insightful contribution. Indeed, we are, as a network, committed to all these values which you just mentioned.